Give me your information or you're going to be coming out of this vehicle.
I can get out, sir, but
Give me your information.
I'm going to turn my video on. Wow.
Get out of the car.
You can't do that for a traffic stop, sir. Please stop it. Why are you being like this? Is how y'all really are? Please stop. This is all on tape. Please stop.
Get out of the car.
Please don't hurt me. Why
Get out.
this? No, sir.
I'm telling you, get out.
I'm telling you that this is not lawful.
All right, you guys, thanks for watching Southern Draw Law. Today we're going to discuss the topic of what your rights and responsibilities are when you were stopped by a law enforcement officer pursuant to a traffic violation. And one of the cases we're going to look at is the clip that you saw at the very beginning of this that comes to us courtesy of the Collegedale Police Department's YouTube page, which I'll leave a link to in the description. And Collegedale is a town or a city just outside of Chattanooga, Tennessee. The subject in question is named Delane Gordon. He was arrested in 2022 by the Collegedale Police Department for the incident that appeared in the beginning of the video. So it presents the question, if an officer asks you or demands or orders you to get out of the vehicle during a traffic stop, are you required to do it? Now, in Mr. Gordon's case, it's a little bit different because what he actually ends up getting pulled out of the car for was not because he refused to get out of the car, but because he refused to give his identification to the officer, at least temporarily. Now, whether or not he eventually would have given his identification to the police officer, we don't know. We know that at some point he had it in his hand. But it really illustrates sort of a misunderstanding of the difference between policy and law, what your rights are as far as negotiating with, debating with the police on the side of the road and that kind of thing, and what, if anything, the police officer can lawfully order you to do in the process of investigating a traffic offense. And so we're going to go through it and have a discussion about the relevant case law and what they got right and wrong in this case. So the first case that we need to take a look at is the one that kind of laid the foundation for what police officers are allowed to do on traffic stops. Before Pennsylvania versus Mimms, which was decided in the late 70s, you basically had Terry versus Ohio that governed investigatory detentions. And so Pennsylvania versus Mimms comes along, and essentially what you have in that case is you have a Philadelphia police officer stopping a person by the name of Harry Mimms for some minor traffic violation. I think it was like an expired registration plate. And the officer testifies that he has a routine of asking everyone he stops for traffic violations to get out of the car for officer safety. And the things that he describes about that are that basically he's not comfortable standing in the roadway with traffic going by and having this interview with this person. And so he always asks him to get out. Well, in the process of asking him to get out, Mimms gets out and the officer notices a bulge in Mimms' jacket that the officer suspects to be a weapon. As a result, he pats Mimms down and determines that he is in possession of a revolver. And so he arrests Mimms and he's later charged and convicted of a weapons violation or a couple different crimes, weapons violations related to that. So Mimms basically appeals to the Supreme Court of Pennsylvania, and Pennsylvania says, no. This is not going to work. This doesn't comply with Terry. There was no reasonable suspicion that he was armed and dangerous, and so the pat down was improper. And asking him to step out of the car was improper. And so the Supreme Court actually came through and said, look, it's dangerous to be a police officer. They carve out this little niche for law enforcement officers that say, look, if the vehicle was lawfully stopped, the Fourth Amendment seizure happened as a result of the stop. So it's really not much more than a slight incremental intrusion into the person's security to ask them to step out of the car when they're already stopped. And so that's Mimms. One of the things that Justice Stevens said in his dissent was that, look, this is going to get extended to passengers too, because if the passengers stop because the driver stopped, they've already been seized under the Fourth Amendment based on probable cause or reasonable suspicion for the traffic stop. So that means that somewhere along the way, we're going to come in and we're going to say, well, it's okay for passengers to step out too. Well, 20 years later, roughly, you had Maryland versus Wilson where that exact thing happened. You had Wilson was a passenger in a vehicle that was stopped. The officers demanded that he get out of the car, and then in the process of dragging him out of the car, a bag of cocaine fell out, and the Supreme Court upheld that and said, look, it's not that much of a big deal to ask the passenger who's already been seized with the driver to step out of the car too. So our holding in Mimms extends to passengers as well. Well, that's been the law of the land again since like the 70s. And then along comes this case called Rodriguez, which basically was kind of like on the coattails of Illinois versus Caballes, that basically said, so essentially in Illinois versus Caballes, while the officer was writing a citation, another officer came along with a canine and walked around the car, and the Supreme Court said that's not a search. The officer didn't abandon his mission of doing the traffic stop in order to let the canine sniff, and so the canine sniff didn't measurably extend the stop and didn't depart from the original mission, so the canine sniff is okay. Well, officers continued to do their thing, and then along comes the case of Rodriguez versus United States in 2015, which didn't really change everything, but it changed some things about Mimms. Because between 1970 and 2015, exactly what Justice Stevens said would happen started happening, which is that police started basically having carte blanche license to order everybody out of the car on a traffic stop. Now, there's a footnote, and I'll link the original opinion down in the description. There's a footnote in Mimms that basically says, and it's considered dicta because it wasn't part of the actual opinion. It was actually a little bit of bickering back and forth between the majority and the dissenting opinion with Justice Stevens. But the majority cites in a footnote in the Mimms opinion that says, unlike what Justice Stevens says is the case, we're not holding that any time a police officer has occasion to speak with the driver of a vehicle, that officer can order the driver out of the vehicle. They clarified in the footnote that only after a vehicle is lawfully stopped for a traffic violation can an officer order a driver out of the vehicle in due course pursuant to officer safety concerns. So that was a footnote. Well, Rodriguez comes along, and basically the government in Rodriguez misinterpreted Illinois versus Caballes' holding, because they basically took Caballes to mean that if you run a dog around a car, it's not a search, so it doesn't matter. Well, what happened in Rodriguez is that Rodriguez is stopped, and the officer writes a warning ticket and finishes the traffic stop, and then hands the ticket to Rodriguez, but then says, you're not free to go, and then they have a dog run around the car. And what the Supreme Court says was that no, the mission of the traffic stop was to take care of the traffic infraction. And when you departed from the mission for the traffic stop to conduct a drug investigation or an investigation for criminal wrongdoing, this person's seizure was over the second that you ended the traffic stop and basically gave him a warning citation. After that, you needed separate, reasonable, articulable suspicion of criminal wrongdoing in order to justify holding him. The dog sniff is not a problem. The dog sniff is not even a search. But holding him in place, not allowing him to go after you've completed your traffic stop for the purposes of doing a dog sniff is a violation of the Fourth Amendment. And so since that time, the Supreme Court and appellate courts have been sort of tightening the belt on the Mimms situation, because officers are using Mimms as a reason to get people out of cars, and then they're misinterpreting the law. And so there's even been a situation recently in Tennessee where there's a case in 2023 where the officers ordered the passenger out of the vehicle, but they didn't cite an officer safety concern. They said, this was a Jackson, Tennessee case, and what they said was, no, we need you to get out of the car because it's the Jackson, Tennessee policy that nobody can be in the vehicle while we run the canine around. And the Tennessee Supreme Court says, no, you can't do that. First of all, if you're going to give the driver or the passenger an exit order, it has to be related to officer safety, and you departed from the mission of investigating this crime so that you could bring a dog around because the driver of the vehicle declined to give you consent to search. And so what happens is the driver says, no, I'm not giving you consent to search, and then the officer sort of got tunnel vision, called a dog because he suspected that there was dope in the car, and they end up dragging the passenger out who is unwilling to come out and arresting him, and in the process a gun falls out and all that. Tennessee Supreme Court overturned that conviction and said, no, can't do that. You abandoned the mission of the traffic stop, which means that this is a Rodriguez case. It's not a Pennsylvania versus Mimms case. That this had nothing to do with anything more than you trying to force a policy down on the person in the car, and because of that you arrested him improperly. You tried to force him out of the car improperly in a way that didn't have anything to do with officer safety. It was about you doing a canine sniff, and we're not going to let it happen. So the Tennessee Supreme Court reversed that conviction. Now, let's get back to the case that we actually started all this about. Now that we know everything we know about Mimms and its progeny, or the cases that came after it, applying all the case law that we've just talked about, let's see whether or not Mr. Gordon is justified in refusing to get out of the car.
What's going on, man?
Hey, how you doing?
Pretty good. I'm Officer just from Collegeville Police Department. Reading the stops whenever you were coming down Talent Road. I got you at 49 and 35.
You sure?
Yes, sir. You what?
I was asking whether you sure about that because I was going to
So what I got you at was 49. You got your driver's license, your insurance card, and your registration on you?
Do you have proof that you got me going there?
I got you by radar, man.
And am I allowed to see? Cause
No, we're not doing that right now. If you want to argue all that, you have to go to court for it.
I'm saying that I wasn't going there.
But I'm saying that you are. So I need your information, please.
Why is it that I can't see proof?
Because it's in my car and you're not getting in my car.
I don't have to get in the car to see it.
I need your information.
Could you get your supervisor so that we can have...
Give me your information or you're going to be coming out of this vehicle.
I can get out, sir, but can
Give me your information.
I'm going to turn my video on. Wow.
Get out of the car.
You can't do that for a traffic stop, sir.
623, start me now. Get out of the car, man.
Please don't touch me, sir.
I'm telling you to get out of the car.
All right, bro, let me turn my video on.
I'm going to tase you. Get the hell out of the car.
Sir, this is a traffic stop. Please don't hurt me, sir. I'm a good kid. Stop.
Get out of the vehicle.
I'm recording you. This is a traffic stop.
I will tase you. Get out.
Traffic stop.
Get out. You will be tased. Get out.
Said he pulled me over for a traffic
Get
stop.
out.
And tase me. You can't do that, officer, because I called for your
Get out.
supervisor. I have.
Get out.
What is the
You
reason?
refuse to give your information. I told you to get out of the car. Now you're resisting. Get out.
I asked to speak to your supervisor.
Get out.
Sir, I feel
Get out.
comfortable. Please get your supervisor.
I don't give a shit what you feel like. I said get out.
Please stop it. Why are you being like this? This is how y'all really are? Please stop. This is all on tape. Please stop.
Get out of the car.
Please don't hurt me. Why
Get
you
out.
doing this? No, sir.
I'm telling you, get out.
I'm telling you that this is not lawful. Oh my God.
Get out.
That's not lawful.
Get out.
That's not lawful.
Get out. Get on the ground.
That's not lawful.
Get on the ground and you're going to taste again.
Okay, but I have my life.
Get on the ground.
That's not lawful.
Get on the ground.
That was not a lawful.
Get on the ground.
Please help.
Get on the ground.
Please help.
Get on the ground.
I'm on the ground, but that's not lawful, sir. I have my license on.
Put your hands behind your back.
Please stop. Help. Please. Please help me. Please help me, Lord. This is not right, sir. I had a right to ask for a supervisor because you. That's not right, sir. I have my license in my hand.
Stand up.
Please help. I can get up, sir, but you don't have to do all this. Why? Why did you have to do this? I just don't understand. I'm a real good person. I'm delivering a DoorDash that goes right there. That was unnecessary.
You're right, it was necessary.
No, it wasn't, sir.
I told you to give me information, you refused to comply.
I didn't refuse.
Yes, you did.
No, I asked a question. I am allowed to ask you.
I need help. Good, thank you, sir.
That wasn't right. That was not right, sir.
Okay, so as you can see, under Pennsylvania versus Mimms, even if Mr. Gordon hadn't refused to give his ID, the officer asking Mr. Gordon to get out of the car was a lawful command. Basically, Pennsylvania versus Mimms stands for the fact that anytime a police officer is constitutionally aware enough to tie his exit order or a command for a driver to step out of the vehicle when it's been lawfully stopped to some issue related to officer safety, the courts are going to uphold it. So, and the same goes for passengers. Now, what I would do if it was me is I would give a little pushback to the police, but now everybody has different styles. People do different things for different reasons. So I'm not telling people what to do or what not to do. This is just my opinion, and you can agree or disagree, and that's okay. For me, what I would probably do is I would ask the officer why, and at least his answer will get him on the record as saying one way or the other. And then I would refuse, and I would say, I'm not going to step out of the vehicle unless you're going to tell me that you're arresting me. And under threat of arrest, then I will step out of the vehicle. But because you can basically make the same point without taking an ass kicking by just preserving the issue by forcing the threat of arrest. Now, if the officer says, no, I'm not going to threaten to arrest you, so well, okay, then I prefer to sit here in the car. But if he threatens to arrest you, then you basically can make the same point. The only difference would be that your damages might differ, right? So like if you take an ass kicking by the police and you have medical bills and that kind of stuff, well, your case might be worth more monetarily than if you just exited under threat of arrest and actually didn't incur any physical damages or any monetary damages. So, but you can still accomplish basically the same thing. It's just that your damage award might be different if you were to win in court. So the long and short of it is, if the police officer is aware enough to tie it to some officer safety concern, Mimms will probably carry the day, or Wilson. If the police officer is asking you to get out of the car because there's a policy related to a canine search or this or that, unless the officer has some reasonable articulable suspicion of a separate crime, then he's abandoned the mission of the traffic stop. If he stops you for a traffic violation, then he's supposed to, the Rodriguez opinion basically says that there are certain things that you can do related to traffic stop, like checking records, checking for warrants, even interviewing the driver about itinerary questions, about travel plans and that kind of thing. All of that's related to road safety, officer safety, and traffic violations. But the second that you start investigating criminal wrongdoing and you put your traffic violation on hold and you're not advancing the mission of the traffic violation, then you've violated the Fourth Amendment, unless somewhere during the questioning or the investigation related to traffic, you've developed some other reasonable articulable suspicion of a different crime. Now, that's not to say that if the officer comes up and he says, get out of the car, and you get out of the car and something is visible to the officer in the process that is illegal, that can't turn into something else. That there have been numerous cases where the person's gotten out of the car and there's been something illegal about the person in that moment, and that has then pivoted from a traffic investigation to a criminal investigation, but it's supported by a plain view of some criminal thing that the officer could then turn into probable cause to search the vehicle, or an odor of marijuana that the officer could then turn into a probable cause to search the vehicle, or whatever. But if it's just an officer asking you to get out, then more than likely that officer's command will be held lawful. And exactly what happened to Mr. Gordon in this case could happen to whoever declines to do that. So that's why I say, for my personal safety, because there's none of this that's worth it to me to go get beat up by the police or potentially lose my life or whatever just to make a point. That ain't me. I'm not willing to do, it's not that important to me. Now, maybe it is to you, and that's an individual decision or individual calculus you'll have to undertake. But the truth is, if the officer gives you an order to get out of the car, it's probably a lawful order. Now, the other thing that you run into, and it's evidenced in this case with Mr. Gordon, is that there is a difference between a police department's policy and actual rights on the roadside. And so, while the law requires that a police officer have reasonable articulable suspicion that a traffic violation has occurred or a probable cause that a crime has been committed before the officer can do an investigatory detention, there's nothing that I'm aware of in my experience or my years as a law enforcement officer or as an attorney that requires an officer to debate that point with a citizen on the side of the road. Now, again, the Collegedale Police Department policy may say that officers have to do certain things. And if they don't do them, then maybe you have an internal complaint against the officer. But the truth of the matter is that you don't have a right to debate the issue on the side of the road with the law enforcement officer. That is something for the courtroom. Now, again, I don't like Mimms. I don't like the holding that you can order somebody out of the car and they have to comply. I think it's less safe when you drag somebody into traffic. I think liability is higher. And, I say this as a post-certified firearms instructor, as a Gracie survival tactics jiu-jitsu instructor for police officers. I don't believe that a person is safer outside of the car. I don't believe the officer's safer with a person outside of the car. A huge number of people in the United States have been to MMA, jiu-jitsu, wrestling, whatever. I just don't believe that officers are safer necessarily by getting somebody out of the car. And if you circle back around, and I would encourage everybody to read Justice Stevens' dissent in this, he basically says, look, this is going to happen over and over and over again. It's going to get extended to the passenger. He basically says the study that you're citing where 12 officers got shot by people who were seated in cars, there were 9 officers that got shot in the same study where the suspect was outside of the car. And so there really isn't anything definitive that suggests that officers are more or less safe, regardless of where the suspect is. The truth is, police officers die because people want to kill them. That doesn't necessarily make an officer or the motoring public safer because an officer wants to get them out of the car. But that doesn't matter. What I think about it doesn't matter, and quite frankly, what you think about it doesn't matter. The law of the land is Mimms is still good law. I just read a case where it was cited yesterday in case law in the 6th Circuit or the 7th Circuit. So Mimms is still good law. Maryland versus Wilson is still good law. Rodriguez is still good law. But I'm going to link the opinions in Mimms. I'm going to link the opinions in Maryland versus Wilson. Rodriguez from 2015. That you guys might find that stuff interesting if you want to go back and read it. But definitely go to the Collegedale Police Department's YouTube page and watch the video in its entirety. This is the stuff that people need to understand. You've got to understand the legal nuances, because if you go asserting rights rights that you don't have, like to demand a supervisor, and you end up getting arrested, you could find yourself either getting hurt, killed by the police, or get convicted of the crimes that you're accused of because you don't understand what's required of you. And so I guarantee you today that if an officer said to me, hey, you're going to have to get out of the car, and I put up my resistance and they said, look, get out of the car, I would get out of the car. Now, what I do after I get out of the car is a completely different matter. More than likely, I'll just sit down somewhere because I don't want to give them any evidence that they can point to say that I was impaired or had balance issues or whatever. All of that being said, always record the police, always assert your rights, and be sure to follow one of my other videos if you want to take a deep dive into some other topics.